Welcome, ladies and gentlemen. This is the matter of State versus Richard Alexander Murdaugh, 2022 GS 15-00592, 593, 594, 595. This is an evidentiary hearing with respect to the defendant's motion for a new trial, which has been remanded to this court from the Court of Appeals where the matter is on appeal paused for the conduct of this hearing. I've got a couple of preliminary things that I'm going to say to our friends in the press. Then I've got some things that I want to say to you as counsel, and then we'll proceed with the examination of the juror. Members of the press, as I explained earlier, this procedure is unique in that typically issues like this are raised immediately after the rendering of a verdict. And we are now almost a year post-verdict in this matter, which makes this a very unusual situation for you and for me to preside over. The defense has asked that jurors be sequestered prior to giving testimony of this motion. To accommodate that request and to accommodate an unavoidable schedule conflict for one juror, that juror is being examined today. The remaining jurors will be examined on Monday. Under South Carolina law, particularly State versus Sinclair, the examination today could take place outside of it and a transcript released at a later time. As a compromise, I am examining one juror today. I have previously had an off-the-record consultation with members of the press, and I'm now going to put on the record what I have discussed. I have asked that the gender of the juror, the questions asked, and the juror's response not be reported until after this court convenes on Monday at 9:30 a.m. for the examination of the balance of the jurors and the clerk of court. The press term is embargo, I think, but what I am asking is that these questions and answers and the gender of the juror be embargoed until 9:30 on Monday. I deeply appreciate the cooperation of the media about this. The behavior has been exemplary throughout. I am very pleased and grateful for the participation of Jay Bender as the media coordinator for this matter, completely voluntary and without pay. And Jay, we really appreciate your assistance, and I know the members of the media do. And again, thank you so much for your cooperation with this request. Now, I have had many communications with both the state and the defense about how to conduct this examination. I have given the state and the defense the questions which I intend to propound to the juror, and as I have explained in my communications, they are loosely based on the examination conducted in State versus Green, which is the last major pronouncement by the South Carolina Supreme Court in 2021 about how issues regarding the possible taint of the jury by some communication from someone not a juror is to be handled. And I have tried to model this procedure on that, although it's very difficult for both parties in this case because of the length of time that has taken place since the verdict was rendered. I have received objections to questions that I am going to propound by both the state and by the defense. Mr. Harcourt, I particularly appreciate your quick response yesterday to the inquiry I made about these questions, and I have taken the comments of Mr. Waters and Mr. Harcourt into account, and I have slightly revised my questions, and I would like Ms. Diaz for you at this time to go to both sides and pass out the copies of the questions as I propose to propound them. Yes, come on by. take a moment, we'll just be at ease. If you can take a moment to examine these questions. Yes, sir.
Your Honor, I have one other matter I'd like to put on the record.
Yes, sir.
Your Honor, I'd move for continuance in my state the grounds.
Yes, of course.
Your Honor, what we're determining is this. These jurors over the next, today and on Monday, will be asked, did Ms. Hill say anything? I mean, the way you're going to ask it. If so, what did she say? And it's unclear as to whether or not you are going to allow us, well, A, that she's going to be required to testify, and B, if so, will you examine her or will we examine her?
You're talking about the
Ms. Hill.
court?
Yes, ma'am.
Thank you for asking that question. I had intended to go over how we're going to operate on Monday after this examination was complete, and we'll do that. But let me just tell you, I certainly anticipate that the state will put this witness up and you will cross-examine this witness. Because there's some uncertainty about what the testimony will be, I will be flexible with the state about how they examine this witness, and I will be flexible with you about how you examine this witness. I reserve the option of asking questions myself at the end if there are things I think have not been covered that need to be covered. But each side will be able to examine the clerk's court.
Your Honor, to that end, and that's one of the reasons.
And now, I've said certain things before about the parameters of what I think needs to be considered in this matter. And I'm not going to go back over all that at the moment, but there may be some limitations on what can be asked, Ms. Hill, because I don't think these questions are aimed at two things. Showing, well, the question aimed at showing what, if anything, the clerk of court said to these jurors might bear on the merits of the matter before they render their verdict. But in addition to that, there are certain questions that are going to be asked that you say goes to the credibility of the witness. I think I am able to fully examine the credibility of the witness without going through everything that has entangled her since the close of this case. And we've already talked about all that. Just let me finish.
I'm sorry. Yes, sir.
And we can talk some more about that, but I'm not going to delay this examination to get into the details of the Hill examination. I have said that only the jurors who sat on this case and rendered the verdict are going to be examined. And I know there's some controversy about how deeply you want to get into questions that you think arise from interaction with the alternate who was dismissed. I take the position that she was dismissed for things that had nothing to do with this Facebook debacle that took place, and Judge Newman made that ruling, and I am following absolutely exactly what the trial judge ruled. We can talk about that some more later, but I don't intend to right now get into the details. So you will know, yes, you will be able to examine this the clerk's court.
But Your Honor, just two minor matters. We would not call any juror about why they were dismissed. That's not what the purpose would be.
I understand the purpose, and you were very eloquent about that, both in your written communications and in what you've argued when we were together last. I understand what your position is about that, and I think you understand mine. But we can talk about that further later.
Okay, just one other matter, and that is we've recently been furnished by the state. First of all, we understand the state spent 6 hours with Ms. Hill preparing for
I think that would be normal in my view to spend time with someone you intended to offer as a witness.
And they've also furnished to us the affidavit for a search warrant, which would indicate that Ms. Hill was somehow involved in the wiretapping by her son.
I am not going to get into that. That is a matter under investigation by the authorities. That is not something I'm going to get into. That's a very kind of thing we've already talked about at some length. I am trying to be very cautious, not out of any protection of the clerk of court, but I believe I can make the decisions that need to be made in this case without touching on matters that are the subject of some sort of other official investigation, and I'm trying to stay away from that.
Well, Your Honor, under Rule 614B, we believe we should be able to have a full and thorough cross-examination of this
I know,
witness.
but I'm not, Mr. Harpoon, two things. You're talking about a motion to continue right now.
Yes, ma'am.
I don't need to get into a full examination of all your arguments about the juror, Clerk of Court Hill right now. I'm not going to do that.
Well, we can't be prepared to cross-examine her without additional time. We're just getting information from the state this week.
Well, I deny the motion to continue, respectfully.
Yes, Your Honor. Thank you.
All right. Now, all right, Mr. Waters.
Nothing from the state, Your Honor.
Subject to all previous objections already lodged, Mr. Harpoon.
No, Your Honor, not as to this juror. I would like to discuss with the courts the logistics for next week.
Sure, we'll have a full discussion of the logistics for Monday as soon as we dismiss the juror.
We're done with the juror.
Thank you, sir.
Subject to our previously made objections.
Very good. Mr. Bland, you may go to your client now and notify her, number one, she's free to leave. Number two, please honor the instructions that I've given with respect to discussing this matter with other jurors. Thank you so much. All right, let's talk about what happens on Monday. My scenario about this is that, of course, the jurors will all be escorted securely to the jury room. I do not propose to have their lawyers with them in the jury room. I do propose to have a bailiff in there. I think there's kind of comfort in numbers, so I don't think they need an individual escort into the jury room. But a bailiff will be with them. I would call them one by one. I will try to come up with some X's, Y's, and Z's to enumerate. And I ask that when we deal with questions for them, that whatever the key is I've developed will be the one you use for these jurors. And I'll get that to you sometime today, I hope. I would bring the jurors to the jury box and give them instructions as I gave and remarks as I gave to this juror today. I will then send them to the jury room, and one by one I will call them to be examined. When the juror is examined, the juror will then be seated in the jury box, and I will go through the numbers until we examine all the jurors. Then I will receive, of course, any further information that is needed from y'all, and then the jurors will be dismissed or allowed to remain in the jury box for the testimony of the clerk of court at their desire. Then the clerk of court would be offered, and I would propose that she be directly examined by the state. But I again say to the state, I will be very flexible about how that examination is done because of the circumstances in which we find ourselves. And I will do the same for the defense and allow free cross-examination. But I will be very sensitive about not straying into areas that simply a further indication of what defense contends is her lack of credibility and her motive for doing whatever it is they say she did. I think I am able to evaluate both of those things and make a determination from that, that is motive testimony and testimony as to what exactly was said and done without exploring the full breadth of matters that may be under examination by other authorities. I don't want to get into that and inadvertently start a proceeding here that would interfere with any other investigation that is being made in connection with this matter. So I'm sensitive about that. And I'll try to do the very best I can. That's all I can do, of course. And you, of course, are going to be free to lodge whatever disagreement with the way I proceed you would care to and have it fully preserved on the record. I have great comfort of knowing that I am simply a trial judge in this matter, and others will evaluate these matters on appeal as it should be. I have not found another case in South Carolina's jurisprudence that is exactly like this. So there's plenty of room for guidance in the court, both Court of Appeals and Supreme Court if they choose to do that. And I am very comfortable with that, and anything you wish to put in the record that would aid in your position about these matters. All right, that said, what things am I not covering, Mr. Waters, that you want covered about the procedure from the state's point of view?
I believe we understand, Your Honor, and everything that you've indicated is acceptable to us. Obviously, we've made arrangements to get the jurors here and brought in a secure fashion, and obviously we're certainly comfortable with them being in a room together. If there's a bail up there, instructing them, of course, not to talk about the merits of anything for this proceeding. And we certainly understand your court's ruling as to the examination of the clerk. We'll be prepared to proceed, and obviously, as we develop, make whatever objections we think are appropriate. But we're comfortable with the court's proceeding.
Thank you, sir. Mr. Harper, please.
Your Honor, who is transporting the jurors here?
Sir?
Who's transporting the jurors here?
SLED, I think, or
Your Honor, we obviously gave the jurors that option. I believe that there may be one that is getting arrived. Other than that, the jurors are transporting themselves. However, just like we did at trial, they will meet at an undisclosed location off-site, and then SLED will escort them in through a secure entrance so that they...
Yes, that is what I had understood, Mr. Harpootlian, is that the state has provided a gathering point for them that is at a distance from having to put up with the traffic and the confusion of the courthouse. And they will then be brought to the courthouse and placed in, and come through the secure entrance and be placed in the jury assembly room. That's how it be handled.
Your Honor, I just state this for the record, and it's going to be an objection I'm going to have to make over and over again. SLED was the original investigating agency. They were the prosecutors, and they continue to interview jurors. The same agency. There's no Chinese wall provision as we would do in private practice. There'd be a Chinese wall. There's no Chinese wall. I'm not sure you can even use that term anymore. I think they call it ethical barrier. Took a deposition in San Francisco not long ago and used that term and got my hat handed to me, if you will. So, but there's no such provision in apparently it's SLED. So it raises questions about the integrity, not of the state, but of the process, which should be avoided. That's number one. Number two, when we examine Ms. Hill, we understand we have a rendition of a statement that was taken, a sworn statement, and then notes from a subsequent. Are there notes from the interview this week?
There was a prep meeting, but even though that was a prep meeting with the attorneys, as I always have, will provide the defense with anything that I believe is in addition to that, which has already been provided. And so as we always do, we'll do that.
And I
we
don't
have conducted this investigation with independence and integrity, and all the SLED agents have been instructed, Your Honor, that they are in no way to do anything but gather the facts, good, bad, or ugly. The SLED agents that will be transporting the jurors are instructed, strict instructions, not at all to discuss the matter of the case. We've been very mindful and careful to ensure that there is no thumb on the scale in this inquiry, and we will continue to do so.
And let me state for the record, I have no question about Mr. Waters' integrity, his intentions, not so much for the police officers. That's my experience, having stood in this courtroom many years as a prosecutor. Sometimes law enforcement officers become overzealous to protect the arrests they made, whether it be a motion to suppress or otherwise. I'm not saying the attorneys in this case in any way have put their thumb on the scales. To the extent that you can Chinese wall it, to the extent that you keep folks insulated, I think is a good thing. The second thing is this. It took about 15 minutes to do this juror. So if we do 11 more jurors, it's going to take 2.5, 3 hours with breaks, I would think, which means we start at 9:30, we probably break for lunch, and then come back and do Ms. Hill. It would be, does that sound reasonable?
Yes.
Okay, and we may attempt to call witnesses after Ms. Hill. Obviously, Your Honor will have to decide at that juncture whether they are appropriate or not, but we may want to make a brief proffer on the record of what they would say. I think we only have one.
Okay.
not the
I'm going to give you
not
some
the
flexibility about that, Mr. Harpootlian. I ruled out having testimonial proffer in this case and told you I wanted it submitted in written form or otherwise. If you choose to put it on the record in verbal form, I won't prevent that. But I'm not going to take up a big block of time taking all kind of other testimony.
should not. The problem is the written when we've submitted written affidavits won't accommodate like the things we heard this morning. I mean, things come up in Ms. Hill's testimony or other jurors' testimony that may be relevant. I mean, the person we have is given an affidavit. It is not the so-called egg lady, okay?
Well, I understand that, and I'm not going to make you recite what you plan until the opportunity presents itself after the testimony of Hill is taken. So know that I would permit some kind of on-the-record proffer. I just don't want to go through a whole bunch of actual testimony in connection. I don't think that's necessary.
Your Honor, I will keep it. I am known for my brevity. Well,
that would be fine.
Thank you.
Mr. You don't need to make a comment about that, Mr. Waters.
I will not make a comment about that, but nothing further from the state, Your Honor. Obviously, there will be bridges that we have to cross when we get to them, and the state will be prepared for that.
Sure, I understand.
Thank you, Your Honor.
Any other issues? I am thinking we can conclude this thing Monday, which would be preferable, of course, but I have, as you know, set aside more days if that were at all necessary, but I am very hopeful for everybody's schedule, including yours, Mr. Harpootlian, that we can conclude tonight on Monday.
Your Honor, I'm in a hurry to get back to the Senate to debate open carry guns. Is something that I'm bated breath awaiting getting out of here and going and do that very important work.
I understand I may be saving you from some things, but in any event, we'll certainly try to accommodate the other obligations that each of you has.
Thank you, Your Honor.
Thank you, Your Honor.
Anything further?
Nothing from the state, Your Honor.
Court will be in recess.